All right, let the record reflect that the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I'd ask the foreperson, has the jury reached a verdict?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff, please. Mr. Johnson, if you'll please rise. We, the jury, find the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by a felon as charged in the indictment. It's got the signature and the printed name of the foreperson. You may be seated. Does either party wish to have the jury polled?
The state does not. Yes, Your Honor.
So what that means, ladies and gentlemen, is I'm just going to go through and ask each one of you individually if this was your decision and your vote. And so I'm going to start on the top and go across and then come back around. So I'll start with the top. Ma'am, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Ma'am, was it yours?
Yes.
Sir?
Yes.
Sir, was it yours? And sir?
Yes.
Ma'am, was it yours? And then we'll come down here. Sir, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Sir, was it yours?
Yes.
And ma'am, was it yours?
Yes.
And sir, was it yours?
Yes.
All right. Thank you very much. And what that means at this time is I will accept your verdict. And at this time, find Mr. Johnson guilty of the offense of unlawful possession of a firearm by a felon. That means that the first phase of the trial is complete, and we'll move into the second phase, which is the punishment phase of the trial. And Mr. Coleman and Mr. Wilkerson, are y'all ready to proceed? Do you need just a short break?
State's ready to proceed. Defense ready, Your Honor.
All right. And so, Mr. Coleman, if you will read the remainder of the indictment. Do you have it handy? Okay.
Said.
That's the enhancement paragraph. He'll need to plead true or not true to that.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery second degree on March 9, 2015 in clause number 14-21127 in the criminal district court of Jefferson County, Texas, against the peace and dignity of the state.
And is that allegation true or not true?
True.
Okay. Have a seat. Right.
That's true.
All right. Let the record reflect state's attorneys present, defendant, and defense counsel are present. I've received a message that the jury has reached a verdict on punishment. You can bring the jury in. Let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I'll ask the foreperson, has the jury reached a verdict on punishment?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff. Mr. Johnson, we, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by a felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at imprisonment in the Texas Department of Criminal Justice for a term of 15 years and no fine. You can have a seat. Does either party wish to have the jury polled?
State, Your Honor. No, Your Honor.
All right, thank you. And so, is there any reason at this point not to pronounce sentence?
Not from the state. Not from the defense.
All right, Mr. Johnson, then at this time, in conformity with the jury's verdict, I sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. You can have a seat, sir. I've handed you two things already. The first is the trial court certification of your right to appeal. Obviously, this was not any type of agreement. You have a right to appeal. Mr. Wilkerson will talk to you about that. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, obviously. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk with Mr. Wilkerson. At this time, I'm going to remand you to the Jefferson County Sheriff's Department until transportation to the Texas Department of Criminal Justice. And ladies and gentlemen, at this time, what that means is that the case is over. I'm going to let them kind of get out of here for a second. I'm going to come visit with you informally just for a few minutes. You'll be released from your instructions that you were previously given. We all appreciate your time. Thank you, Mr. Coleman, Mr. Smith. Thank you, Mr. Wilson. And at this time, you can take Mr. Johnson to the back. And court will be in recess. If everyone would please excuse yourself from the courtroom. Good morning, sir. Are you Jeremiah Davis? And this is 250066, and Mr. Davis is charged with assault on a peace officer. And what is the announcement?
Your Honor, we're asking for a little more time. We have an offer on the case, and he wants to bring me some discovery that he thinks would help the prosecution
Okay.
make a different evaluation. And so I told him he needs to call me this week and make an appointment. He's called me before, but I think he's just been able to get this
Okay.
information.
Mr. Smith, any issue?
No.
All right, so Mr. Davis, I'll reset your case about 30 days. Make sure you get that done early on. Don't wait till the last minute before court so Mr. Parker can get what you have. He can get it to Mr. Smith, and then we can see where we get the next court date. All right, you're free to go, sir. Mr. Shetley, in cause number 240776, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from October 22nd of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 2 years up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 2-year deferred probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
That's correct.
All right, and Mr. Parker, you're hired, correct?
Yes, ma'am.
All right, Mr. Parker, we'll begin preparation for trial, and we'll get it set on the next available trial docket.
One thing, Judge, just, I think I have all the discovery that I need to confirm. In the discovery, it references a flash drive that was provided to the Groves Police Department. And I don't know if that's some of the discovery I have, or if there's actual flash drive that I need to get a hold of. And
Okay,
one other
perfect.
thing is the photos, if I can get it. Yeah, because the computer doesn't show it.
Okay, perfect. All right, thank you. Stay in touch with Mr. Parker. He'll tell you when you need to be back. Good morning, sir. You're Charles Young, and this is 250102, and you're charged with burglary of a habitation. And Mr. Wilkerson, what is the announcement?
Judge, we're going to ask.
Notice what's happening here. This is one of those courtroom moments that sounds routine, but it actually tells you the defense is still scrambling for leverage. When an attorney asks for one more setting, it usually means theirs. Evidence missing, witnesses not fully lined up, or strategy still developing behind the scenes. And the mention of the VA records, it could completely shift how this case is viewed depending on what's inside those documents.
We're going to ask, I'd like to request one more announcement setting. Still working on some information, and there's some additional information also that I need from the VA's office.
Okay. Has there been any issue with regard to bond conditions, Ms. Malfino?
No, Your Honor.
Well, if you recall, there was a hearing.
Yeah, that's what it
with regard
meant.
to that matter. I'm still trying to get the evidence behind that hearing. So, in terms of what was alleged, like pictures, screenshots, messages, anything related
I
to.
uploaded all that discovery last week.
Okay, all right, sounds like it's all been
And a lot of
uploaded.
that, just so the court is aware, has come from the complainant calling the front desk, making reports for Renee, who then reports it to me. I just filed that motion, not to be punitive against the defendant, just to make sure the court was aware so that there could be a no contact for both of the parties either way. And everything that I have to bring to discuss.
Perfect. All right, so Mr. Young, I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Wilkerson so we can try to get an announcement at the next court date. All right, thank you, Mr. Wilkerson.
What makes this whole courtroom session fascinating is how many lives are moving through the system at once. One defendant gets sentenced to 15 years. Another is negotiating evidence. Another rejects a plea deal and risks trial. Same courtroom, completely different futures, unfolding in real time. So here's the question. If you were offered probation, instead of risking years in prison at trial,